You can hear me, obviously.
Well, let's get started, and if you don't hear us, people, please wave and indicate. But welcome to tonight's constitutional conversation. We're doing something quite different tonight. Our guest, the Honorable Doug Ginsburg, former Chief Judge of the D.C. Circuit Court of Appeals, and was on that court since about, 1984? 86. So a real veteran of the federal judiciary. Before that was Assistant Attorney General in the Antitrust Division and a Harvard Law School professor. So very honored, quite an honor to have him with us. But what we're doing here tonight is that Doug has been asked, and has in fact produced, a PBS documentary on the Constitution. And so, and it's entitled A More or Less Perfect Union. It will appear when?
It will start appearing around the country on the 24th of January. KQED will play it on the 28th. Oh, my. Well, I'll just have to speak more clearly. The program will be available streaming from PBS's website on as of the 24th of this month. KQED will show it, all 3 episodes, on the 28th. And then it'll be around the country, different PBS stations over the next couple or 3 months.
Okay, so great. And so so we're getting a taste of this. And how we're going to proceed here is that Doug has selected some segments from the documentary. We'll look at those segments, and then he and I will have a little conversation about it. I'm not quite sure what my role is here. I think it's like Mortimer Snurd, maybe, but we'll see how it goes.
Well, I guess I'll say, just by way of introduction.
Maybe you could just talk into it.
Thank you, Richard. If I swallow it like that, is that good? Okay. All right. Good enough. All right. I have to chew on it. All right. So this program is meant to, my intention anyway, and that of the Free to Choose Media that produced it, is to bring to the PBS audience, and then beyond that, the debate that the Federalist Society brought into law schools about, starting in the 1980s, about the methodological debate over interpretation of the Constitution. Original public meaning, as opposed to what Justice Brennan called a living Constitution. And we'll start with just some excerpts to try to capture that debate. The long-term and value in the program is going to be also that it will be cut up into segments that are used for school history and civics classes. The Free to Choose Media has an affiliate foundation, or educational foundation, called IZZIT.org, IZZIT.org, and there'll be 170,000 teachers receiving a lesson each week, and there's another set of 4 for Black History Month. So this would be, I think, of current interest for several years. Things don't change that quickly. Can you hear me in the back? My wife seems not to. People behind you can hear me. Well, that's because I'm chewing on the microphone.
Would it be better for us to have the...
Oh, yeah, that sounds like a good solution. We'll do that in addition. How's that?
Testing.
DC? Okay, problem solved. All right, so we will we'll roll tape and get this debate going. Please, Mike.
Make an introduction. You may not have seen him in the audience, but the producer of this program is the same person. Many here will be of my age, at least, will remember the extraordinary documentary called Free to Choose, which was a series of interviews with Milton Friedman back in
1980.
1980. And so that producer is with us tonight and is the producer of this as well. Can you just wave to folks? And so
That's Bob Chichester.
And so afterwards, if you have any questions about production of a documentary like this, I bet he could be we could twist his arm, I bet, and get him to answer a question. I had the pleasure, just by chance, to have dinner at his table last night. So,
and since 1980, Free to Choose Media has been producing things for public television year in and year out, including a biography of a program about Aaron Director, who was a member of the faculty here. Okay, here we go. See if this works.
The written Constitution is all that matters. We, the people, is how it starts.
I'm afraid too many people worship the Constitution. We are being ruled by people who have been dead for 200 years.
How should the living interpret the words of the dead? The debate comes down to the document's original meaning versus a living Constitution.
Originalism is simply the proposition that the meaning of the text of the Constitution must remain the same until it's properly changed.
It's actually very hard to discover, often, what the original meaning was, because the text of the Constitution often doesn't give you that much guidance.
And I think we delude ourselves if we believe that there is some objective meaning or correct answer.
I don't believe that. If that's true, I can't see the point of having a written Constitution in the first place.
I'm one of the living guys. I believe that the Constitution is ever evolving.
There are going to be circumstances where we have to interpret the meaning of a word. I happen to be fairly limited in how far I'm willing to go.
But originalism does not say, and stick with that through eternity. Article 5 of the Constitution specifically contemplated that the Constitution could and should be amended.
The problem is the Article 5 amendment process is extremely difficult. It's very, very hard. I think the best way to think about a written Constitution is it's a starting point, but it's not the ending point.
Of course, we do our best to understand what the text meant at the time, but for all of the debatable issues, that's a starting point.
If you're a living constitutionalist, it can be whatever you want it to mean. In fact, the only living constitution is a constitution that's followed.
That has almost nothing to do with modern judicial review because in all modern cases of any importance, the Constitution is not clear.
We're not writing on a blank slate, but we are filling in the blanks and figuring out what the Constitution should be.
The Constitution does evolve, but it evolves slowly. It evolves with the time. It needs to be tweaked.
All of us agree that the Constitution should be updated. What we disagree on is who is to do the updating.
That's what the political process is for, to resolve those difficult questions.
The last people you want to be changing that document are judges.
The judiciary is not licensed by the Constitution to add to or subtract from the text of the Constitution.
What the Supreme Court says it means is not actually the Constitution. The Constitution is the Constitution.
The idea that the Constitution should evolve is really inconsistent with it being the law of the land, the supreme law of the land. The alternative is a law that's forever uncertain, no more stable, no more reliable than popular opinion of the time. Opinions change, mores change, the words don't.
So, Doug, what do you really think?
Yeah, I know I tipped my hand there a little bit. I think that when the Supreme Court has departed from the original meaning of the Constitution, it has more often than not been disastrous. The court invented a right to own slaves and a prohibition it invented on African Americans ever becoming citizens. The court read equal to mean separate but equal. We'll get to some examples with the Commerce Clause and the Takings Clause, and they have been transformative and I think disastrous for the Republic.
What concerns me about the living Constitution is not just maybe that it evolves, but question is, who's driving the bus? It seems to me that we hear much of the rhetoric about the living Constitution uses the first person plural. We interpret the Constitution, but who is we? Is it judges or is it the American people? It seems to me that living constitutionalism could be achieved perhaps more accurately if the court would just interpret the Constitution only to address questions that the Constitution actually addresses, and only to limit the legislature in the ways that the Constitution actually limits the legislature, and otherwise let the people decide what the rules would be. That would be living in the sense that we, the people, would be able to get what we think is best. When the judges do it, though, we don't get. This is not living in a sense of a democratic system. It's much. The judiciary is by far the most elite and aristocratic and privileged and unrepresentative branch of our government. Why should they be the ones to decide how the living Constitution evolves?
Well, when the court departs from the text in a way that brings within its ambit, or purports to bring into the Constitution, some subject matter that simply isn't covered by it, it takes it out of the realm of politics. That's what Judge Brown was talking about. These are things that would otherwise be resolved through the political process. We can start with a simple example, which is Roe versus Wade, which was riding the tide of the first women's movement of that era. With there was a great force to that, and the states, in virtually every state, several had changed their laws. I think more than a dozen. All of them were debating it, and a few, I think, had decided not to change their laws. That decision truncated the debate, froze it where it was. And the decision was not the product of a democratic process. It was simply a bolt from on high, saying, you stop arguing about this, here's the answer. I think it was in 2004 when Justice Ginsburg, Ruth Ginsburg, spoke at NYU about this and made exactly the same point, that it truncated the political debate, which is why I would say, and I draw here on some good comparative work done by Marianne Glendon at Harvard, which is why in her book, Abortion and Divorce in Western Law, survey of 23 countries, why that issue remains essentially unresolved in the sense that there is a significant portion of the population that doesn't accept it as legitimate. If the same decision or some decision came out of the political process, it would be, we as Americans accept that as a legitimate outcome. We've had a voice, and the difference is that in the political process, there's compromise. There has to be in order for anything to come out of it. In a court, somebody wins and somebody loses. And that leaves the situation festering.
It's also odd. So most believers in the living Constitution also have a strong view of stare decisis, that is precedent, that once Roe versus Wade or some other case of that sort is handed down, oh no, you can never, it would be quite illegitimate to reconsider it. Well, what kind of a living Constitution is that? It's like it lives until the court decides something and then it stops living anymore.
Well, it stops, it's living in the sense that it can expand. It can't contract the realm of control given to the court. Chief Justice Marshall, in a document other than, well, let me first say that in Marbury versus Madison itself, he said the virtue of the written Constitution was that one could hold legislation up against the Constitution and see whether it is or is not within the powers assigned to the legislature. And in a separate document, he wrote that the written Constitution was the greatest political innovation. I don't know if he said ever or of modern times. That was the concept. That was the conception. We're going to write these things down. There's going to be a checklist there. In a way, it was similarly part of the debate over whether to have a Bill of Rights. They're saying if we put in a checklist, the implication would be that nothing else is protected. So Madison puts in the Ninth Amendment. It says don't draw that implication, which of course is what actually happened. There are very few, well, I guess no rights outside the Bill of Rights that have been recognized. They put another way. When the Supreme Court invents a right, they plug it into some phrase in the Constitution or the Bill of Rights. Equal protection, due process, something. Instead of saying rather straightforwardly, under the Ninth Amendment, look, there's a reservation here of the rights retained by the people. We'll get to the question later in my slides, if you like, about how they find that.
I had the benefit of doing a preview here, so I know we'll get to that. How about we move on to the Commerce Clause?
Sure. Okay. So here's what it says. It's pretty straightforward. Congress will have the power to regulate commerce among the several states. We can accurately capture that by just saying interstate commerce, things that move across state lines. And that's how it was interpreted initially, including federal power over, early on, ports, for instance, which are sort of essential to that process. But it doesn't include mining or manufacturing or labor relations or all these other retailing things that occur in one state. Now, the goods might move interstate, and that can be regulated. The transportation could be regulated, but not the goods themselves, not the manufacturer, not the labor relations. And that their thing stood until 1937. So as an example, in Adkins, I think 1913, the child labor case, the legislature, the Congress had tried to regulate products made with child labor, and the court said, no, you can't do that. That's occurring locally in the state. And the state can do that, but you, the Congress, cannot do that. And that all changes in 1937 in the Jones and Laughlin Steel case, which upheld those provisions, upheld the National Labor Relations Act, bringing the national government into the regulation of labor management relationships. Skip forward just a little bit to 1942, and we get the further extension of that.
Ernest Hemingway slept here. Now they do, descendants of Hemingway's six-toed cats. The Hemingway home is dedicated to preserving the legacy of author Ernest Hemingway and of his cats. In Key West, anything goes. Chickens need no reason to cross the road, or a license, for that matter. But when the Federal Department of Agriculture got wind of the museum's cats, it dictated how they should be cared for.
The museum challenged it on Commerce Clause grounds and said these cats are marooned at the very southern tip of Florida, will never cross a state line, and furthermore, they were not bought or sold, they were merely born.
To the framers, commerce meant I send something to you in Boston when I'm in New York. That was interstate commerce of the kind that could be regulated. When two people in the same state traded something, that was not interstate commerce and therefore could not be federally regulated. That was the intention of the framers.
The framers didn't design an almighty federal government that could reach down right into your backyard or barnyard.
During World War II, there was a farmer who grew grain, and he fed that grain to his own animals.
And the federal government had a program at the time that dictated how much wheat farmers could grow on their own land. And he said, hey, that's not constitutional. Why? Because I'm not engaged in interstate commerce.
But in Wickard versus Filburn, the highest court in the land thought otherwise.
And in a convoluted analysis, the Supreme Court declared that because that wheat would not be used in interstate commerce, it still impacted interstate commerce through some type of displacement.
So they're taking the Commerce Clause and stretching it like a rubber band to apply to any kind of business when it was originally meant just to be for cross-border commerce, like it says.
I agree, but some scholars disagree. In their view, there's little, if anything, beyond the regulatory authority of the federal government.
In an economy like ours, things really are interconnected. And what goes on one farmer's farm really does affect what happens elsewhere. And so when the Supreme Court says the Interstate Commerce Clause gives Congress the power to regulate things that seem awfully local, it's not just engaging in some kind of trap to expand federal power. It's recognizing an economic reality.
If the test under the Commerce Clause becomes, does it affect commerce, then everything affects commerce, whether you do something or don't do something.
Well, once you have the power over anything that affects commerce amongst the states, then you basically have the power over everything.
Everything? Even Hemingway's cats?
The 11th Circuit Court of Appeals, and I kid you not, said that because the museum features these cats on its website and has cat-related merchandise in its gift shop, that is a substantial connection to interstate commerce, and that opens the door for the federal government to come in and exert control. Not making that up.
So there's one mistake in there. John Baker says if you do something, you don't do something, it affects interstate commerce. But in National Federation of Independent Businesses against Sebelius, the case in which the Supreme Court upheld Obamacare, the ACA, the court, by 5-4, said no, not buying insurance, which was punishable on the ground initially that it was interstate commerce, affected interstate commerce. That is not within the federal regulatory power because the Constitution, and this must have shocked the government lawyers, he actually quoted the Constitution. The Constitution says that the federal government, Congress may regulate commerce, not compel commerce. So a little bit of originalism went a long way there to tell us that, no, well, at least not doing something is beyond the reach of the federal government. If your backyard's wet for 14 days a year, it may be a wetland and subject to federal regulation. So there's the text as it's been revised by that's the statement in Wicker. It doesn't matter if it's local, it may not be regarded as commerce, so it's now local non-commerce as opposed to interstate commerce. As long as it has a substantial economic effect on interstate commerce, and that can be direct or indirect, then it's within the power of the federal government. Now, substantial economic effect has actually, I think, since then been, if you look at the cases, I would say more accurately now stands as discernible effect on commerce. Here's what happens to the clause. That's where we are now. Substantially or maybe discernibly affecting commerce. That is obviously not the government that we were bequeathed in the Constitution. It may be a government that's necessary or advisable under current circumstances. It is the government of the United Kingdom. The central government has the same authority. I gave a talk recently entitled, We Fought a Revolution and Got a Constitution, Was It Worth It? Because we ended up in the same place. Of course, we had more fun getting there.
Chris, so these subjects are a little bit different from what we were talking about with the last set of slides, because there we were talking about ways in which the courts would use, shall we say, fanciful or imaginative interpretations of the Constitution to do things contrary to what the people want, but to impose rules on the people that they didn't vote for. But every one of the examples you're talking about here are programs that the people's representatives voted for. This is the people of the United States appear to believe, whether you like it or I like it or anybody else like, they appear to believe that the federal government should be regulating the national economy. Does that give you a little bit of pause when to say that the court should be standing in the way of that?
No, it's an example of a different problem. Instead of removing from the political process things that were outside the Constitution and bringing them in, it's failing to perform its anti-majoritarian role, which is to say, whatever the people may want is subject to the limitations of the Constitution. They can change it through the amendment process, but in order to protect electoral minorities, you don't allow the majority to depart, or that was the idea, to depart from the Constitution. Once you allow that, then every interest group is at the trough trying to do just that, and of course the thing departs ever more. Now, if I can just elaborate in one respect that's not shown here, the people's representatives voted for the legislation that gave rise to the Wickard against the wheat case, farmers' wheat. But the agency that they authorized, that created the regulation limiting what farmers could grow, was never voted on by the people or their representatives. So today we have a system in which, because of this approval of the Congress exceeding its authority, we have, in addition, approval of the Congress delegating that authority to agencies that pass regulations, enact regulations with the force of law, that administer the regulations, that accuse people of having violated them, and then judge whether they have done so. So we've combined, and the court has condoned what the Congress did, combining all three functions of the three branches in the same hands, what Madison called, quote, the very definition of tyranny. People didn't vote for any of that.
So we can talk about delegation, but first let's talk about commerce. Is it so clear that some of these things do not involve the regulation of commerce among the states? So take, for example, Roscoe Filburn in the wheat case. We hear about what he did, but we didn't actually hear what Congress did. So what Congress did was to pass a law which says that no one, essentially I'm paraphrasing here, but no one may sell their wheat or other products in interstate commerce, meaning across state lines, unless they comply with our limits on how much you can grow. And so Filburn could have grown wheat for his own horses. What he couldn't do was grow wheat and sell it in the market, which is what most of his wheat, that's what he did with most of his wheat, was he sold it in interstate commerce. He couldn't sell it in interstate commerce without complying with the regs. Why isn't that regulation of interstate commerce?
Well, that portion may have been, or was, but the court upheld application of the quantitative limit to the wheat that he did not sell in interstate commerce.
Yes, but they can. The point being that his business is selling wheat in interstate commerce, and he has to comply with the rules about how much wheat you grow if you're going to be able to sell in interstate commerce.
Well, only if
it may be oppressive in various ways, but I don't quite see why it isn't regulation of interstate commerce.
Well, to say as a condition of engaging in interstate commerce, you must do things that we want you to do that are not interstate commerce. What used to be called unconstitutional condition, I think, right? But now it might be called leveraging of some sort. So if they'd said, well, you can, if you want to participate in selling your goods in interstate commerce, then you also have to use certain fertilizers, not use certain fertilizers, because we don't want you to be too productive. I'm not sure that would be regulating interstate commerce. The goods would be in interstate commerce, but the fertilizer on his land hardly seems like it. If that's not a good example, you can certainly think of some conditions attached to his participating in interstate commerce that in fact just are a lever for regulating something that's not in interstate commerce.
And I also wonder how this fits with our talk about, in the first slide, about original meaning. It seems to me it's one thing when the court says that the Constitution sort of means something that it never meant, but it's something else when the concepts used in the Constitution, because of economic or social change, simply have a different impact today. So at the time of the Constitution, markets were localized. That's because conditions of transportation and communication were so limited that there was some interstate commerce then, but most economic activity actually was pretty local. And that's the state of the economy then. But today, it's actually very difficult to come up with examples of economic activity that aren't part of a national market scheme. When I write constitutional law exams, I desperately try to come up with realistic examples of economic activity that really is just local. I managed to do it, but I tell you, it's pretty hard to come up with them.
That's because you're trying to avoid the affecting commerce provision, right? That's been written into it. At the time of the founding, the problem with the economy was that the states, the 13 states of the original Union, had erected trade barriers against each other. They would not allow out-of-staters to fish in their waters. They issued their own currencies, which inhibited transactions. The economy was in a deep depression when the Constitution was written in order to replace the Articles of Confederation, which were not working. They created a national market, an enormous advantage for commerce. That doesn't mean that because they were successful in facilitating commerce, that it somehow extended their authority beyond the interstate movement of goods. Take labor relations. Yes, labor relations at the Ford plant at River Rouge in 1937, a sit-in, affected interstate commerce because Ford couldn't ship automobiles in interstate commerce. The labor relations are not, it's themselves, interstate commerce.
I'd be happy to talk about Commerce Clause all day long, as my students here in the room will testify.
Okay. So here's a different example, more in the frame of the Commerce Clause than it is of inventing rights. Here we have the Takings Clause as it appears in both the Fifth and 14th Amendments. Right? Fifth Amendment in the Bill of Rights, applying, constraining the federal government, extended to the 14th Amendment in these terms. Okay? And we then get to the case that some of you are familiar with, the Kelo case in 2005, in which the court essentially substitutes public purpose for public use. Interestingly, it cites a case from, I think, 1895, in which the court had talked about public purpose, saying public use is too narrow a limitation on the government. Because after all, if they take the property to build a theater, people use the theater. If they take it to build a hotel, the public uses the hotel. So there has to be a public purpose, i.e. in addition to a public use. And then, in I think rather cynical way, in Kelo, they cite that case for saying, oh, public purpose isn't anything new. We broadened the terminology a long time ago. Indeed, they had done, even before the turn of the century, in order to allow eminent domain power being vested in railroads. The transcontinental railroads and other interstate railroads had to assemble a right-of-way. And condemnation was the only possible way to do that, whether done by the state or by the railroad. And of course, it's quite the same as a public building, a public school, or a public highway. But they said, well, it's close enough. It's going to be used by the public, and it's going to be subject to regulation. Then in Kelo, the facts are that the City of New London decides that they want to increase the tax yield from some land adjacent to the downtown. It's not entirely blighted, but they condemn the land in order to turn it over to Pfizer, a drug company, to build an office and research campus there. And Suzette Kelo didn't want to sell her house, even at the fair market value, which was what they would have to pay. So she resisted that, and it went to the Supreme Court, and the court said, well, look, this economic development's a public purpose, so increasing the tax yield is a public purpose, so the government can take that. In other words, the local legislature can decide what's a public purpose, in that case, the town council. So they essentially revised the clause to say a public purpose, including economic development. I'm not sure if it was 3 or 5 years. I think it might have been 5 years. Or anyway, the few years preceding the Kelo, before the Kelo case, there were around the country about 5,500 examples of eminent domain being used for economic development. It was becoming quite common. In the 1 year after Kelo, there were 6,500. So it had about tripled or whatever it was because of the permission granted by this rereading or revising or rewriting of the constitutional provision. Things didn't quite stop there because the public, being aware that their property rights were being destabilized, objected quite strenuously, and now 46 states have enacted legislation, some of it not very forceful, some extremely restrictive, limiting the degree to which towns and counties can condemn land. So in Florida, for instance, there were instances just before Kelo in 1999 of the town of West Palm Beach acquiring 100 acres by eminent domain to be used by a private developer for a golf course. The golf course never got built. The land stood vacant for probably 10 years, something like that. It was finally sold to a local university that built on it. So Florida enacted a law that prohibits the use of eminent domain for economic development. An exception requires a 3/5 vote of both houses of the state legislature. And if land is acquired this way, presumably with permission, it cannot be resold for 10 years to a private party. So that's the most restrictive instance of law in the states. Some of the limitations that were passed are relatively toothless, at least certainly compared to that. What do we got next? Oh, yes, I'm sorry, sure. Here's an example.
As a kid growing up with pianos, I remember the first time I ever broke a string, my dad said, "You broke it, Charlie, you're going to fix it." The first musical director of one of the casinos, he came to me and said, "Charlie, I have a lot of pianos here." So that's what started my career in piano tuning in Atlantic City.
At the beginning of the 20th century, Atlantic City was America's playground. But after World War II, its fortunes declined. The city then gambled on casinos and lost big. Much of America's playground is now a casino wasteland.
This building is not just walls. This building is a cross-section of my life. It's like a living, breathing thing. We were blessed to be able to come as immigrants to this country after what my parents had survived the Holocaust. And the idea of actually owning something that we couldn't be thrown out of was huge.
But maybe Charlie could be thrown out. In 2014, a state judge ruled the Casino Reinvestment Development Authority could seize Charlie's home, using the state's power of eminent domain.
And you have 45 days to vacate, and that it would be bulldozed as all the other buildings right next to me had been bulldozed.
Does the public use provision of the Fifth Amendment have any meaning whatsoever? And the Supreme Court's answer by a 5-4 vote was effectively no.
The Constitution provides that private property may be taken for a public use with just compensation paid. But the Supreme Court rewrote public use to read public purpose, which is much broader.
And the thing that was crazy in the Birnbaum case is they weren't even sure exactly what they were going to use it for or when they were going to use it.
They said, we don't have to give you an answer. I'm thinking, where do we live? Is this Russia? Is this North Korea?
It's just a naked abuse of government power.
So Charlie went to court. 2 years later, the judge deemed the state's effort to oust Charlie a manifest abuse of the eminent domain power. New Jersey appealed, but in the end, Charlie prevailed. In the infamous case of Kelo versus New London, Suzette Kelo wasn't so lucky. The Supreme Court said, we can't decide what a public purpose is. We'll let the city councils decide that. That's good enough for us. Funny, but I had thought the justices were supposed to make constitutional decisions.
So the battle goes on.
So Charlie won in the
Three branches of government divide power. But
Charlie won on appeal in the New Jersey appellate court. And I don't know if there was any statute at all, but the appellate court ruling is the relevant authority now in his case. And it's basically because the authority didn't have any immediate plan for use of the property for an economic development that I think they really recoiled. The court recoiled from that.
Well, the takings clause is one of my favorites. My last argument in the Supreme Court a few years ago is what I call the Raisin Case, and I'll tell that story quickly. You should have used the Raisin Case here instead of the piano tuners. How about raisin farmers? So my clients had almost 47%, almost half of their raisin crop taken by an agency of the federal government without being paid anything for it. What did the agency then do with it? Well, they sold the raisins in the open market and then used the money to subsidize raisin export, to provide export subsidies, all of which went to the 2 or 3 largest raisin entities in the country. I call that a taking.
A regulatory taking.
After losing 3 times in the Ninth Circuit, we finally won 8-1 in the Supreme Court.
One of my favorites is, if I recall it correctly, the South Carolina Coastal Commission. Richard will know about this, in which the Coastal Commission wanted to say that the owner couldn't build anything on this property, and they claimed it was a regulatory taking. And the commission said, well, no, you can use it for camping. So we haven't taken all of the value of the property, which was close to the standard. And the Supreme Court said, no, that would not wash. And then it went into compensation phase, and the price turned out to be $900,000. And then the commission said, actually, we don't really want this property. Thank you.
Well, I think some of the hardest takings cases are where the government regulates the use of property, and the effect of regulating the use is that property becomes much less valuable than it was. And we currently have, I think, a doctrine which neither side finds very satisfactory, because the rule is that they require compensation if, but only if, substantially all of the value is diminished. Well, this is a little bit like saying that if you have like 100 acres of property and the government takes 1 acre in order to build a post office on it, that you're not entitled to any compensation because, you've got 99% of the value left.
It is not a very satisfactory situation, to say the least. Should we venture on?
3 branches of government divide power. But Madison feared one branch might seize the power of another. His solution came from Isaac Newton.
And Newton was the hottest guy around. He was the new theory of physics. He looked most closely at this concept of different bodies, planetary bodies, and how they affect each other, how they could be locked into orbit with each other.
And the gizmo that illustrates that is called an orrery.
An orrery is a model of the solar system.
Peter Grimwood is an engineer. His hobby is orreries.
They were used as basically rich man's toys to impress your friends. They started off in the 1700s when it was firmly established that the sun was in the middle and the planets went round. This was something very, very new, and it all made sense. A planetary system is something that's always in motion, always in balance. Gravity's pulling them in, centrifugal force is pulling them out, and the two balance each other out, and so they go round in a fixed orbit.
When you have 3 planets locked in orbit, it is remarkably stable unless you let one planet grow in size. Then the entire orbit becomes unstable.
How do you contain political ambition, the most dynamic, destabilizing force in the entire world? Madison figured it out. You force ambition to counteract other ambition. And that's what the Constitution does. Brilliant.
They knew the corrupting effect of power. They knew that greed, avarice, envy, all of those things would be at work.
He pitted their ambitions against each other. He took what was a flaw in human beings and he turned it into a positive.
The framers gave us 3 branches of government with carefully separated powers. But the Congress and the President then created a 4th branch, so-called independent agencies, a whole alphabet soup.
They produce regulations, which are the primary law now. We live in the age of regulation.
There are over 180,000 pages in the Code of Federal Regulations. In 2016, the Congress passed 214 new laws. But the federal regulatory agencies issued 18 times as many, 3,853. And we didn't vote on this, and neither did our representatives in Congress. How did this happen?
What is the big one of the 1930s, the mother of all agencies?
An act was passed creating the TVA, the Tennessee Valley Authority.
Let's dam the river. Let's get power from that. Let's teach farmers to farm more productively.
There was this belief back in those days that essentially you could have government by expert. You just bring in the right experts and they'll know exactly how much coal we should produce and how many sneakers to have.
The architects, the research chemists, the agricultural experts.
To operate a scheme like that, you have to have executive agencies. That's where that came from.
With what safeguards have we delegated these powers? To whom exactly have we delegated them? What's the kind of scope? With what provisions for judicial review?
There's nothing magical about the institutional forms that the framers gave us. And if things adapt over time and seem to make sense, then that's good.
And if the legislative branch chooses to delegate so much of its power or pass laws that basically put all this power in agencies, then it seems like that's their prerogative to do it.
Now we have a federal government that intrudes into every aspect of everybody's life. I don't think that there is a person in the country who can go through a day without violating some federal regulation or rule.
And large chunks of the federal government are unconstitutional because there's simply no enumerated power to authorize what the federal government is doing.
When you talk about agencies, there's one word that's out of the discussion, and that is states.
Now, the federal government routinely taxes and takes more money than it needs solely to give it back to the states with conditions. Now we have agencies that have every element of a government unto themselves.
And they combine all the powers that the framers so carefully separated. They pass rules that have the force of law, legislating. They enforce those rules, an executive function. And they judge who's been in violation of those rules, a judicial function. Perhaps worst of all, as the framers feared, they are unaccountable to the people.
That is one of the most fundamental errors you can make in all of political science, to combine those powers in one branch, and we have done it.
When agencies write their own laws, or presidents write their own treaties, whether we notice or not, they're chipping away at our liberties. So this is part of a general phenomenon in which the Congress has tried to avoid responsibility, not just by delegation and the sort we're talking about here, but also, for instance, when it comes to treaties. Right, so the Iran deal that President Obama entered into was an executive agreement. Yeah, I don't recall any senator saying, wait a minute, we didn't vote on this. Treaties have to be ratified by the Senate. Why would one want to have to do that and be accountable to the voters? So this is a constant theme. Avoid responsibility and just get reelected.
Actually, there were quite a few senators who said that the Iran agreement should be submitted.
I'd like to know who they were.
One of them, interestingly, was Bob Menendez, who was the chair of the Foreign Relations Committee from President Obama's own political party. Obama was not even going to give the Congress the terms of the agreement, and Congress passed a special bill applicable to that, in which they said basically, if you give us all of the papers, all of the documents that tell us what the agreement was, then we will give an up or down majority vote on whether we approve it or not. Note that a treaty has to be approved by 2/3 of the Senate. This would be a majority of both the House and the Senate. That vote then took place. The president said he would veto it if it went down, and so it didn't pass. It's actually rather similar to right now a vote being taken over the War Powers Resolution in Iran, where because the president when the president threatens a veto, that means that he's going to prevail with only 1/3 of either of the two houses of Congress. So
The War Powers Act is an interesting outlier because there the Congress really asserted itself by passing it in what year was it, Mike? 74? Mm-hmm. Yeah, when the executive was in a very weak position. We had an unelected president. But its constitutionality has never been really determined, has it?
Well, I think everyone, sort of left and right, assumes that the guts of it are unconstitutional, not because of war powers, but because of one-house vetoes. So the Supreme Court in 1983, in a case called INS versus Chadha, held, probably correctly, that it's not constitutional for Congress to pass laws giving itself a one-house or even a two-house veto. The idea of these one-house vetoes is let the president or the executive branch do things, but if we, the Congress, don't like what they did, all we have to do is pass a simple resolution in one house, not subject to the president's veto power, and then that will reverse the executive branch action. In the Chadha case, the court, reading Article 1, Section 7, said no, the legislature cannot act in that way. When the legislature acts with the force of law, it can only do so by virtue of a bill, which is passed by both houses of Congress and then submitted to the president for the signature. That completely gutted the War Powers Act. It also guts a number of other things, including, this is the real story behind the Emergency Powers Act that President Trump has been using so aggressively for building the wall and other purposes. The Emergency Powers Act gives the president vast emergency powers with no real standards at all, but that statute, which was passed before the Chadha case, provided that Congress, either house of Congress, by a one-house veto, would be able to reverse the president's finding of emergency. Well, once Chadha comes down, the Emergency Powers Act, rather than being a restriction on the president because of the congressional veto, becomes a blank check, and the president can defend his powers simply by vetoing, which means he gets his way with as few as 1/3 of either House of Congress. If 1/3 of either House of Congress is on his side, then he prevails.
Mike, weren't there about 200 statutes with one House vetoes?
That's right.
Yeah. Now, when President Nixon acted, I don't know if that was under earlier legislation, but again, it had been a delegation by the Congress. What President Nixon did was lawful, was within that delegation, imposing wage and price controls on virtually the entire economy, suspending gold convertibility, I don't know what else, by declaring an emergency in the eye of the beholder. So this is not the Congress that we expected. Go on. Let's see what's it. All right. See what else.
3 branches of government divide
We
power.
did that. Where are we? Yeah. Okay. Let's see. How can I get it to play? I don't want to go further. I want it to play.
I don't know. I left my quill pen at home.
Somebody, Travis, where are you? Just use this. Nick? No, oh, okay. So maybe I thought there was one. Let's see. It should be here. That's where it is. Maybe that's where it is. Okay. All right. Okay, so here are the due process clauses in the 5th and 14th Amendments. Pretty straightforward, at least in the to say. No person deprived of.
In the due process clip, how do we get out of that clip to the next clip?
I think we're one too far now, aren't we? Not the first due process one, just the text. We had the both of them. Yeah, okay. All right, sure. Then okay, so there are the due process clauses now. What's about to come out is simply that the Supreme Court has now, for some time, determined that that there is a substantive component to the due process clause. Although process is inherently procedural, they've divided it between procedure and substance. Well, you want to go to the 9th Amendment? Okay. All right. This is not covered in the show, beyond saying that it's never been used. The only time the 9th Amendment appears, as far as I can tell, in a Supreme Court case is Griswold. Is there any other, Mike?
Mentioned in some concurring opinions and also in the Richmond newspapers case.
That for the court, the opinion for the court? Okay. So here it is.
But never a clear holding.
Yeah, even in Griswold, it's
essentially never been applied.
Yeah. In Griswold, it's one of 4 or 5, I think 5 provisions in the Bill of Rights from which the court discerns a zone of privacy that includes marital privacy. In that case, was the state of Connecticut had prohibited the sale of contraceptive materials even to married couples, to anyone. And so it's played this not even cameo role, no substantive role in the Supreme Court's jurisprudence. Now, it could have been. I'm not sure what theories there are as to why the court has never done this. It could have been a quite productive source of rulings of the sort that the court has been making in recent years, dealing with, as in Griswold, with that discerned right of privacy, dealing, as in Roe, with the right to abortion, dealing in more recent times with same-sex marriage. Those things all could have been argued under the Ninth Amendment, whether they would have succeeded or not. I don't think they were probably even presented in that respect because it's just lain dormant. But the question that I've raised here, and again, it's not in the show, is where were these rights to be found? One could imagine that they were the natural law rights, either those referred to in the Declaration as our unalienable rights, or from some more elaborated version or commentary on natural law. Perhaps the rights of Englishmen as of 1789, that's what they wanted by having a revolution, to reclaim the rights of Englishmen, or by a common law growing out of that, a continuing common law of the Constitution, unconnected except by the Ninth Amendment itself. Comment?
Well, in addition to where are the rights to be found, it's what do you do with them when you find them? Because note what the verb is in the Ninth Amendment. It says that the rights shall not be construed to deny or disparage others retained by the people. So where does that leave them? If they're not going to be denied or disparaged, some people think that they become constitutional rights, just like freedom of speech or takings or whatever. That isn't really quite what it says. It doesn't say that they become constitutional rights. It says that they won't be denied or disparaged, which seems to imply that they won't be given any less authority or weight than they had before the enactment of the Bill of Rights.
Yes, but that's not inconsiderable. Let's go back to abortion. The common law rule was that abortion was not an offense by either the doctor or the patient before the fetus was quick, which for a first pregnancy would be 18 to 20 weeks. For a multigravidated subsequent pregnancy, it would be 16 to 18, I think. So it was a perfectly serviceable rule. And it could have been invoked to say women have a right and doctors have a right until the fetus is quick.
On the other hand, it's pretty clear that they did not intend to freeze the common law into place. In fact, we know that because of what they actually did. Jefferson, for example, went through the entire common law of Virginia saying, this part we ought to retain, this part we shouldn't retain. They didn't mean to say that common law rules were fixed. Common law rules are in place until displaced by the legislature. So the question is, with respect, to use your abortion example, why did the legislature lose its ability to be able to displace the common law in that area when they had the right to displace the common law elsewhere? Is that what you think the Ninth Amendment means?
Well, I've put out three possibilities there. I don't endorse any one of them. I'm asking, as I say, it's not covered in the show because I wouldn't know what to think.
What happens to them? So it could be natural law, could be common law, or it could be a continuing common law, meaning I think the judges get to make it up. Is that what you mean?
That's what we usually mean by that, right? Not make it up. Don't be. That's disparaging, isn't it?
Or denying, yeah.
Or maybe even discovering. So Mike, you see your question then is really why couldn't the state overrule that, as it can do with respect to other matters of common law? If it doesn't mean that the state would be prohibited in that respect, what does that leave? What does it mean? What could it mean then?
Well, I have a theory that, first of all, I think natural law is the most likely of the three possibilities, just because of surrounding context. And I have a theory that what it meant is that natural law would have the same force after the adoption of the Bill of Rights that it had before the adoption of the Bill of Rights. And so then you have to look to, well, what force did natural law have in the courts of Britain and the early states? And, that's not an easy question, but I think the best answer to the question is that natural law was a backdrop understanding. It was enforced through what they would have called Blackstonian equitable interpretation, which meant that that statutes would be read narrowly to avoid violation of natural law. But when now I'm quoting from an 1785 New York court decision, which in which, by the way, Alexander Hamilton was a lawyer, and the court said that when the court intentionally and specifically intends to displace the natural law, that the legislature wins.
There were innumerable cases in which the courts said that statutes in derogation of the common law are to be construed narrowly. But that's that's common law rather than natural law, yes. Right?
Right.
Yeah. Well, insofar as natural law had any vitality sufficient to overcome or limit an act of Parliament, I'm tired of hearing about Bonham's case. It seems to be an outlier in Cook's commentaries. And not something that really had any significant role in the English courts. I think the courts of the states, the early states, gave it a little more sway.
What cases?
I don't have particular cases. I've read commentary only to the effect that there were, I think maybe Gordon Wood deals with this, that there were a number of state court decisions in which courts purported to, did hold some statute, local statute, state statute, void under the natural law theory.
Well, there is a natural law of time, and I think we've run out of it.
No time for questions.
Do we have time for like 10 minutes for questions?
I think 7:15.
Why don't you take...
Yeah. So if you have a question, I'll bring you the microphone. So just go ahead and raise your hand if you have a question for the judge.
Either judge.
John Samples, Cato Institute. 3 decisions of the Supreme Court under the First Amendment: Schenck, Dennis, and Brandenburg. Can originalism tell us which one of those was the correct application of the First Amendment?
Well, this is going to the question of the meaning of abridgment here, I think, right? As to what was the state of the law before the First Amendment said it shall not be abridged, that right shall not be abridged. And I think the amount of learning on that is rather modest, to say the least. Am I missing something like?
It's a hard question, but I think that while Brandenburg may have gone too far, some of it may be slightly an exaggeration. Jefferson said, and I think he's a considerable, authority here. He said that words and sentiments cannot be punished until they break out into overt acts against peace and good order. And so that's not quite the same as Brandenburg's formulation, but I think it points in the same direction. The idea being that just because what people say has a sort of general bad tendency, maybe it promotes immorality or disrespect for the government or something, that isn't good enough. That we have to wait until it breaks out into overt acts against good order.
Well, I think the phrase was imminent incitement to violence, which would suggest that the incitement could be you could stop before the violence occurs. Once the incitement is there, that's a fine line to draw.
That's Brandenburg.
Yeah, exactly. It doesn't require an outbreak of violence. Right? You can catch it in time. But I think it's pretty clear that whatever it meant in 1791, when the First Amendment was added, was inconsistent with the Sedition Act of 1798, under which publishers were fined and imprisoned for criticizing the president or his cabinet.
See a hand over here.
Well, I did have my hand up. No, I mean, I'm not going to do it. I'm going to go back to Hammond and Dagenhart. I'm going to go back to Hammond and Dagenhart on the Commerce Clause because I
Why
think
isn't this, your mic doesn't seem to be working.
Hello, Dolly.
There you go.